Thank you. Welcome everybody to the Abbey of Neumünster. Sorry for the pronunciation. I am French and I'm not sure that it's a good way to pronounce the name of the Abbey. On behalf of the Center for Law and Economics of Sport of Limoges, I want to say thank you everybody to be here, both in person here in the room in the Abbey and online, because this conference is live streamed on our YouTube channel. It's a pleasure to be here, and an honor also to have many people involved with us on the program. Thank you very much to all our partners that helped us a lot to organize and build the conference on a very short notice. I want to say thank you, to the University of Luxembourg, with which we have been organizing this event, but also to the other academic partners, the University of Limoges, because we are linked to the University of Limoges, the Faculty of Law of the University of Rijeka in Croatia, the University College of Northern Denmark, Sport and EU, the association Sport and EU, and also the International Association of Sports Economists. I would also like to give a special thanks to all the speakers that are here today to speak about this very interesting and accurate topic right now because of the debates that we have around the Super League case. So thank you very much for taking part in this conference and for your confidence. That few words being said, just a few reasons about the organization of this conference. As you all know, a couple of months ago, the Super League failed to be launched, but there is still a case pending to the European Court of Justice. So we were thinking that it was relevant and interesting to organize such a debate, academic debate with academic experts, on these legal and economics aspects of the organization of football in Europe, but also more widely about the European sport model, because that's the real also problem behind all the debates we have right now. It is a really important topic for us at CDES, because we have been working on many studies on this topic around the years, and especially the last few years. We did two studies. The first one for the French Ministry of Sport, which was dedicated to the impact of the creation of closed leagues on domestic competitions. This study, unfortunately, has never been published by the French Ministry of Sport, so maybe one day. And the second study, which has been published, and you can find it on our website, and you have been distributing it here in the room, has been done for the French National Olympic Committee, and was dedicated to the European sport model. And to finally introduce this conference, I will ask to my colleagues Nathalie Alaphilippe, a lawyer at CDS, and Jean-François Brocard, to give you the main and principal insights of these two works. So I call them on the stage, and you have the floor.
Hi everyone, I'm going to take the floor, Nathalie, if you don't mind. It's a pleasure for me to be here and to talk about this very important topic. The current organization of football is just an illustration of the institutionalization of sport, which originates in England at the end of the 19th century, when the first clubs and the first federations were created. The process of institutionalization was pretty long, and at the beginning of the 20th century, we could already observe some common pillars that appear to create an organization, a model of organization of sport in Europe. This model quickly widespread with the Commonwealth in the European ports, and a century later, of course, we already mentioned it. There's diversity according to countries, there's diversity according to sports, but still, we can definitely identify pillars that are able to define what we call the European model of sports. I'm going to focus on 4 pillars, but we could, of course, think of other ones. The first pillar is the monopoly of federations. The second pillar is the regulatory power of those federations, which have the power to regulate their sport. The third one is the membership of athletes in clubs and the membership of those clubs in federations. And the fourth pillar is, of course, the organization of the competitions in this pyramidal system with the porosity between the different floors of the pyramid and the promotion and relegation phenomenon that illustrates how can those competitions be porous. This model, as I described, is facing challenges at the moment because it faces competition from the private commercial market on the top of this pyramid, but with the Super League, with the EuroLeague in basketball, but also at the bottom of the pyramid. That leads actors from the sport movement to wonder about the sustainability of the model and in turn about their own future. So that led CDS to be commissioned to conduct different studies that Christophe already mentioned, and that gave us, I want to say, expertise on the subject, and that's really why we're really happy to highlight today some findings of those studies with two perspectives, the economic perspective and the legal perspective with Nathalie. On an economic standpoint, sport is peculiar for two reasons. It's peculiar because it's a specific economic good, and it's also peculiar because it's a specific sector. And those two aspects should explain why sport deserves a specific treatment. First, sport is a specific economic good. One of the findings of our studies was that the European sports model, as I described, should be defended because sport is a very specific economic good. It should be considered as a collective good. That means that the impact of sport, the impact of producing sport, the impact of consuming sport cannot be all monetized. The impact on sport on health, the impact of sport, the sport consumption, the sport production, on citizenship, the impact of sport on socialization, it cannot be monetized. It's very difficult to evaluate it and to create revenues out of it. What the economic theory predicts when that's the case is that if you ask a private actor to produce sport, it's got to underproduce sport compared to the social optimum because it's going to focus on what's profitable in sport. In fact, if you want to take into account these social impacts of sport, you need to implement a broad cross-cutting policy, and that's only governments that can do it. You cannot ask private companies to do it because that's not going to be profitable for them. In this context, it's important also to mention and to present the principles of sport, and actually we think that it's the principle that constitutes sport as a collective good. Of course, the solidarity was already mentioned, and the solidarity, of course, is very important. We are always talking about the vertical solidarity, so coming from the top of the pyramid when it creates revenues to the bottom of the pyramid, and it's always important to remind that UEFA and IOC redistribute more than 95% of their revenues. The other principle, which is very important, is the talent development, which is the ability to develop talent. This is a very risky, very costly, middle to long-term investment that is not easy to tackle. The third principle that constitutes sport as a collective good is the territorial grid, the territorial coverage of sport. Sport should be offered to all peoples without distinction of social category, of solvency, of place of residence. And in fact, sport should be used by governments to plan their land use. The fourth principle is the integrity of the competitions, the mental and the physical integrity of athletes, and those shouldn't be negotiable. Why is it so important to present those pillars, to present those principles when we want to defend, when we want to prove the reasoning behind the defense of such a model? That's because all the alternative models to what we call the European sports model proved inefficient in respecting these principles. We can mention the European initiatives EuroLeague, for example. ECA, a private company, is organizing 2 competitions, EuroLeague and EuroCup, and they hardly respect those principles. They do very little in respecting these principles. But we can also mention the North American leagues. They're always used as examples of how closed leagues are the solutions to all problems that sports faces. But if you look a little bit in detail, the NBA, the NFL, they don't do anything about solidarity. The best they do is called charity, and for Europeans, that's very far from what we call solidarity. They do pretty much nothing about integrity. When they decide to tackle integrity, that's only because this has implications on the revenues they can generate. Look at how they tackle doping, for example. Look at how they tackle betting. That's opportunistic, okay? And finally, NBA, NFL doesn't develop talent. They externalize this as well. They externalize, and they're really lucky because they get talent for pretty much free because of their university system, and because we, in Europe and in Africa, in other parts of the world, we still produce talent. But that's not generalizable, you know? Everybody cannot be the free rider in talent development, okay? Those leagues, those closed leagues that are like the dream in America, they cannot be imported in Europe for different reasons: tax, legal, social, maybe cultural reasons. And when they are important, when the closed league system is imported, like we have in EuroLeague, for example, it's an economic failure. Let's talk about it. It's important to remind that all the clubs that participate in the EuroLeague, actually, they lose money year in, year out. And some clubs actually lose a lot of money. Barcelona, look at the balance sheets. It's not the solution for sport. It never proved that it was the solution. UEFA and other competition organizers are criticized at the moment because of their little efforts in solidarity, their little consideration of sporting meritocracy, etc. But let's not forget that the current situation, which is definitely subject to critics and to debate, is just the outcome of 30 years of threats by big clubs of breakaway, which led UEFA to give them more money and to give them easier access to the competitions. So that's why a couple colleagues of mine, Van der Burg, Beck, and Prince, they published a very interesting article in December 22, pretending that actually what should be illegal should be those threats made by big clubs, not the fact that UEFA is organizing the competition as a monopoly. The threats from big clubs should be made illegal. So that was my first argument. Sport is a very specific economic good. But the second argument is that sport is a very specific sector. It's a specific sector because athletes, clubs, they need competitors. Coca-Cola would be very happy to be the only provider of cola in the world. In sport, it's different. You need competitors. And if you seek revenues, you need good competitors. You don't only need competitors, you need good competitors, because you actually co-produce the competition that is eventually sold to the spectators, to the TV viewers, to the TV companies, etc., etc. And this product that you co-produce with your fellow opponents on the field is what is gonna be the product that's gonna generate revenues for you. One of the specific feature of this competition is gonna be the uncertainty of outcome. That's proven. There's many studies. If the competition is less and less uncertain, it creates less revenues. So that explains also why sport deserves a specific treatment when it comes to competition law, of course. And that's another reason why we believe it deserves a specific treatment. Those economic elements were presented just to highlight why we at CDS believe that this model should be defended, with just one condition: that the institutions still believe that sport is a collective good and still respect the principles that make sport a collective good. Of course, sport is not above the law, and there were many, many moments when law tried to tackle sport, and that's going to be Nathalie to talk about it. Yeah.
Thank you. Is it working? Yes? Okay. Hi, everyone. So yes, thank you, Jean-François, for setting the scene from an economic perspective, and let's now look at it from a legal perspective. I think it has been mentioned already, but everybody will agree that today football in Europe is at the heart of the debates on what we commonly refer to the European sport model. And with, of course, the very much awaited decision of the Court of Justice on the Super League case. So from a legal point of view, these debates, I think, lead us to address the question of the articulation of the legal system of sport and the European Union. Two legal systems that have been scrutinizing and testing each other, I'd say, since the creation of the EEC 66 years ago, with the pendulum swinging back and forth ever since, looking for a satisfactory position, satisfactory balance when they meet. The areas where the two legal systems meet vary in density, without this area being set in stone. And if I may, I will borrow a distinction made by Professor François Alaphilippe in 1987, who, for the record, with Professor Jean-Pierre Caracchio, created the Center for Law and Economic of Sport in 1978. So, when analyzing the relationship between law and sport, Professor François Alaphilippe identified three main zones of density, which I think can easily be transposed to the relationship between EU law and sport. With one, a zone of maximum sport density, where we find the rules of the game, and in principle outside the scope of EU law. A zone of what we call a minimum sports density, where sport and EU law rarely meet. For example, I don't think sport is really concerned with EU tax law and VAT. And then three, a more complex and heterogeneous zone, where the autonomy of the sporting organization in regulating and organizing their sport, faced with EU competition law, but also other important aspects of European law, such as, for example, prohibition of discrimination on grounds of nationality or freedom of movement of workers. So the question is, in this complex zone, where is the balancing point that would allow the two legal systems to live in harmony and in the sole interest of this very special good that Jean-François mentioned a moment ago, that is sport and the values it conveys? In order to illustrate this complex relationship, let's go back in time a little bit. So the early days. For a very long time, sport lived in a belief that because of its specific nature, its history, its anteriority, but also its global dimension, it had nothing to do with EU law. In short, the sport movement lived in kind of a bubble, according to which EU law was not applicable to sport. The first very hesitant meeting point between the two legal systems took place in the 70s with the very well-known judgments Walrave and Dona. Without EU institutions maybe not really knowing at the time how to deal with this new topic. For the Court of Justice, sport falls within the scope of EU law only insofar as it constitutes an economic activity. Well, distinction that the sport movement interpreted, at the time, as a sporting exception in its favor and as giving it the right to bypass EU law. Hence, the rules on national team quotas or those on transfer fees for players at the end of a contract. For the latter, it should be mentioned that while transfer fees persisted at international level until the Bosman ruling, some member states, such as France, for example, had already abolished them. Then came the second period in the relationship between the two legal systems, going from what we often refer to as the Bosman Revolution to the Mecca Medina case. I think we can say that the Bosman ruling in 1995 turned everything upside down and shifted the pendulum very strongly in the direction of EU law, particularly in reaction to the fact that at this time, UEFA and FIFA did not appear to show a lot of interest in the European institution. The cases that followed, from De Liège to Simontenkov, extended the effects of the Bosman ruling to countries outside the EU through the cooperation and association agreements signed by the EU with third countries. In the end, since the rule of international sport organizations are intended to be universal, the effects of EU law on sport have practically been extended to the entire planet by the combined effect of the Bosman ruling together with the subsequent cases and the regulatory changes operated by international sport organizations with the view to global harmonization. Since Bosman, the European authorities have constantly extended the scope of application of EU law, gradually closer to the submission of sport to competition law. And finally, the culmination point, or the culmination of the swing in the direction of EU law, was reached with the Mecca Medina case in 2006, in which the Court of Justice decided that all sporting rules, even in the area of maximum sporting density, can fall within the scope of EU law, and competition law in particular. The third stage, which is up to this point the final stage, is marked by a real consideration of the specificity of sport. Indeed, the pendulum started to swing back the other way, led by politicians and not judges, with the adoption of Article 165, which explicitly requires that the specific nature of sport be recognized. The concept, obviously, of specificity of sport and its recognition by EU institutions did not start in 2007. The trigger being, without a doubt, the Bosman ruling. As early as 1997, the European Parliament recognized the specificity of sport and the autonomy of the sport movement, and constantly urged the European Court of Justice and the European Commission to respect this through its resolution. In the Helsinki report, the European Parliament states that the specificity of sport should be taken into account when applying the competition rules of the treaty to the sports sector. The European Council has also contributed to the promotion of the specificity of sport by, for example, reminding the European institution to consult sports associations when important issues relating to sport are concerned, or in taking a clear position in favor of preserving the core value of sport, such as solidarity, fairness of competition, and physical integrity of athletes in the Nice Declaration. The high point of recognition of the concept of specificity of sport is, of course, the white paper on sport in 2007, for the adoption of which consultation with all stakeholders played a key role. For example, in 2005, the Commission set up a consultation framework with the sport movement and the member states under the name the EU and Sport Matching Expectations, which main objective was to reinforce the promotion of European sport and its special characteristic in EU policy making, but also to achieve more legal clarity. And the European Commission continued to defend the concept of the specificity of sport after the adoption of the Article 165, as with its report on developing the European dimension in sport in 2011, in which the Commission clarifies the function of the specificity of sport. So there is therefore, and has been for a long time, a strong common will of the European institutions to take into consideration the specificity of sport. And it's then not surprising that at the time, the Mecca Medina judgment was seen both legally and politically as a major step backwards. However, despite the feeling of incomprehension this case generated, it must be recognized that not only have the European institutions since fully grasped the concept of the specificity of sport, but have integrated it perfectly into the decision-making process in matters of sport litigations. When European judges opt for the proportionality test in order to verify whether a sporting rule is compatible with the fundamental freedom or EU competition law, they choose to put forward the specificity of sport and permit the contested sporting rule to evade European law as long as it complies with this proportionality test. In a way, I think we can say that this test promotes, or at least facilitates, the establishment of a dialogue around the rules issued by sport institutions. And it gives them the chance to explain the objectives that these rules are supposed to achieve by proving their legitimacy, as well as the necessity and proportionality of the means implemented to achieve them. So although this mechanism is not a guarantee of optimal security for the sports movement, it's true that the case-by-case analysis does not make it possible to identify objective principles that would apply de facto to sporting rules. It remains that the recognition and use of the specificity of sport demonstrate that the European courts are aware of the special nature of sport and its values, which distinguish it from any other economic sector. With the forthcoming ruling on the Super League case, I think we can say we are at a tipping point. At a point where we may well see the pendulum stop at a position that is satisfactory for both EU law and the legal system of international sport organization, right in the middle of this very complex and heterogeneous area where the two legal systems should combine harmoniously, if possible. So, the purpose of this conference is, of course, to analyze and comment on current developments regarding the organization of football in Europe, to discuss why and how to preserve its specificities, but also to show that what is at stake goes far beyond football. It's time now for debate, and I wish you all a very, very nice conference. Thank you.